All right. Good afternoon. It is May 14, and we are talking today about privacy issues in the Zoom era, particularly for family law cases. Everybody should be on mute except for our panelists and me. And then if you have comments or questions that you want an opportunity to talk, you can raise your hand or send a chat, and if we have a chance, we'll call on people. So I wanted to start off by introducing our wonderful panel. We have Judge Kathleen McCarthy from the Wayne County Circuit Court. She's the presiding judge of the Family Law Division. And I want to thank her especially for keeping the family law attorneys up to date by giving us frequent emails on the family law listserv. And even though I do not practice in the trial court and not in Wayne County, I just find it very appreciated, not just by me, but by all the other attorneys. So thank you, Judge McCarthy. We also have Ryan Kelly, who's at the family law firm of Kelly and Kelly in Northville, and David Mendelson, who is in Birmingham at Mendelson Law Firm. Thank you all for joining us today. So before we get started, I wanted to share, so one of the things, the impetus for this whole conversation is now we're doing Zoom. A lot of places are going to be doing Zoom hearings for a long time, not just motion hearings, but evidentiary hearings, and Judge McCarthy can address that in a second. But the impetus for this discussion today are the privacy issues that come about because the Supreme Court has said that when you have a hearing via Zoom, you still have to make it publicly available. And so we have the Administrative Order 2020-8, I believe is the one. There's 4 requirements that are required for our Zoom hearings by the Michigan Supreme Court. And then after I say that, you're not going to be hearing from me as much today. I'm going to be leaving it for the panelists to share all their thoughts and ideas. But we have to have procedures that are consistent with the party's constitutional rights. The procedure must enable confidential communication between the party and their attorney. Access to the proceeding must be provided to the public either during the proceeding or immediately after via access to a video recording of the proceeding, unless it's a closed case. And finally, the procedure must enable the person conducting the hearing to make a recording for a reporter. So that's what the impetus of this whole issue was when we discovered everything was going to be in the recommended format is to do YouTube Live. So first I want to hear, I guess, from Judge McCarthy about what Wayne County is doing as far as Zoom hearings. And then we can start talking about what we can do to the things that we're concerned about for our clients' sakes, and maybe what we can do to protect our clients' privacy.
Sure. So we have virtual courtrooms set up on our webpage, 3rdcc.org/Zoom. And every judge and referee has a virtual courtroom that you just access that website. You click on join meeting and you're in an open meeting. And then next to that, we have our live stream button. So any person in the public can go and click on that button and you'll see what is live streaming next to any judge or referee while the proceeding is happening. We're not saving or recording those live streams in any way. So it's only open to the public. If it's Smith versus Smith and their hearing is at 9 o'clock, you can go into the Smith versus Smith hearing at 9 o'clock and view whatever's going on. Again, it's not being recorded. So if you miss the live stream, then you have missed that recording. So, and that's on purpose so that we cut down the inappropriate contact with the public as much as possible. That's how our whole entire court, all the divisions are set up.
So Ryan or David, have either one of you had an opportunity to have a Zoom hearing yet?
I have. I've had several Zoom hearings already. I've done several Zoom mediations, and I've done both motion call, referee, pre-motion hearings, and status conferences in Wayne County. So I've done all 3.
I have, and I've done them in Wayne County and in courts that are using the the second option that you talked about, Lisa, which was the notion of we're going to record it and then put it up on YouTube Live, I think, for a 24-hour period following the hearing. And, that has its own host of problems because things are said maybe confidential information is disclosed, and now someone can go later on in the evening when they're bored or have nothing else to do and go hunt down that recording. So the way Judge McCarthy, you described it, is certainly my preference, but there's probably pros and cons for both.
And I think we had Judge Yost here 2 weeks ago, and that was exactly what she was doing, the same thing as Judge McCarthy. It was only on YouTube Live, and Judge Feeney's nodding her head as well. It was only on YouTube Live for the hearing, and then it was gone. So here's the thing. Today I had the opportunity to go watch a hearing, and I wanted to watch this hearing because it was a case that I won in the Court of Appeals, and they were having a post-Court of Appeal hearing. I'm like, oh, well, I guess I can go watch it. I don't usually but I'll just go check it out, see what's going on, to see how the judge is going to act and how the parties are going to, or the attorneys are going to act. And so I had to find the judge's YouTube room. So I think it was by judge. Like, I don't think it was like the whole county, but you have to find the room, the live room for that particular judge. And then you have to be there. And I had it open and nothing was happening. And then all of a sudden the feed popped up because that's when the proceedings started. Is that how it's working? For the people, in the audience, if you have experienced this, is that how it's working? You have to actually go find the judge's YouTube, not just the county or the family division of Oakland County or whatever.
Correct. I mean, I've been trying every morning to just kind of look around and see whose courtroom I can watch. It's kind of fun. And unfortunately, I'm not seeing a lot of action because I just must hit it at the wrong time. But then I've tried to go back and search in Wayne to see if I can pull up specifically Judge McCarthy's courtroom and find anything on YouTube, kind of troubleshooting it. I couldn't find anything after the fact, but I did watch a couple hearings in other Wayne County courtrooms this morning. It was really interesting.
But Lisa, I would think that Ryan's experience and the one that you just described is also a mild buffer to help address these privacy concerns, because as we know, our courts don't always start hearings exactly on time because they're either obviously doing something else or a hearing runs over or whatever the case may be. So if you think your neighbor's hearing is starting at 10 o'clock and you log in at 10 o'clock and you just get this blank screen, for most of our public, I think they're going to think that they've either done it wrong or they don't have the access that they're thinking they have, and they might not be as patient as you might.
David, you hit the nail on the head, and I think this is another, at least if we're going to do YouTube Live, it's sort of a benefit that it disappears. But when I went today, it didn't start at 8:30. I think it didn't start till like 8:36 or 8:37, and I was just like, did she tell me the wrong time? Was I mistaken? Did something happen that I didn't know about? And then I went and pulled the notice of hearing. I'm like, no, it's the right time and day. And then all of a sudden, boom, it just showed up. So I didn't realize, sometimes there's been courtrooms that we've seen where you can tell you're in the courtroom, that you're in a live courtroom, maybe nobody's there, but you can tell like it's the live view of the courtroom. And so that might make you more patient, but if it's not, if there's nothing there until it starts, the regular viewing public may not realize that they need to be patient, which is fine. So let's talk about first the concerns we have about protecting privacy and what things are gonna come out or who's gonna be watching during a YouTube Live. I've had various scenarios that have been shared with me of concerns. And I think one big one was that if the case involves children who are old enough to find things on YouTube, that a child that is a part of the case might watch, or maybe even worse, their teenage friends might be watching, who are gonna tell everybody, in school, like what's going on in so-and-so's family. I don't know if anybody has had experience with that. If anybody out there in the public has, go ahead and put something in the chat. But panelists, have you share some of the concerns that you've heard about, I guess?
I haven't heard of any of those concerns yet, and I think the way that we have our live streaming set up, I think is the best way to mitigate that type of thing, because just as you indicated, those kids would need to know exactly what time their parents' hearing is, or the neighbors are going to have to know exactly what time. So that is something, that the parents and the litigants themselves can somewhat control by not divulging that information.
So they would have to know, Ryan, I think you said you were able to, you can go to Wayne County and see the docket if you know where to go. So So that would be like levels of complication as far as being able to find it. I've also, go ahead,
But
Ryan.
children are resourceful, and so are other people. And I think if somebody's really dedicated to get in and watch that hearing at the same time, they will do it. I think because we're so early in these stages, I think that these privacy concerns are just starting. Not only that, but other members of extended families. Often their parents will know when their hearing is, or their sibling, and they'll be able to view that proceeding. Then what they will do with the content that's shared in that proceeding is a concern for clients going through this process.
And I want to add, while I recognize the need or the argument regarding open courtrooms, when there's an open courtroom, at least we know who's sitting there. I know what neighbor has decided to log in. I know what family member has decided to log in. We know at a later proceeding if that family member testifies. We know if they've been watching the proceedings to date, and it might be something that the court might be interested in. In this scenario, we really don't know who's looking and who's watching. And so I think we have to be as cautious as possible with what we place on the record, which is, I know, something we're going to get to later in our discussion, but we don't have the benefit of knowing who actually has seen the hearing, where I can turn it before all of this started, we could turn around and see the 6 people sitting in the courtroom behind us.
Right. I think Judge McCarthy, you made the point the other day when we talked about, well, you can't really do anything about it, the fact that there's people in the courtroom. But to David's point, you at least know who's there, and that might, I don't know that it changes anything, but it just.
And you certainly are more limited in sequestering witnesses. Clearly, if I had a contested hearing and all those neighbors that were coming to testify, they would go out in the hallway, and we don't have this benefit with this live streaming. So I agree, there's real concerns.
So let's talk about the sequestered witness, because that's one of the potential people who might be watching when they shouldn't be. Do you just cure that hopefully by giving them an instruction at the beginning of the hearing, make sure all the witnesses who are sequestered are being instructed not to attempt to watch anything? Or how do you, or do you just have to ask them questions once they get on the stand?
Sure, you can give those instructions, and I think there's restrictive orders that could be entered, but just as everyone has said, it's not going to stop those few people that don't have that integrity, and so it's a real issue.
Mm-hmm.
So some of the other concerns really we're going to get to when we talk about how to protect our clients. So I'm thinking about financial and medical information. Let's switch to starting to protect them. We're in the middle of an evidentiary hearing that has to do with financial and medical information. And in a lot of my cases, as an appellate attorney, a lot of that medical information is like psychological evaluations and allegations of mental disorders, which can be obviously a hot topic of conversation among people who maybe shouldn't be hearing about it. What do you have as a suggestion, Ryan or David, to protect your client's privacy when you have to get out the medical or financial information without necessarily sharing it with the world?
Right. But I think one thing that we talked about a lot, David and I have talked about, as well as some other attorneys, is really preparing your clients for what is to come in this new world of Zoom hearings, including YouTube live streaming. They need to understand, we've been able to talk to our clients about the costs of litigation and the time and the expense and the sheer nature of and toll of that experience. Now we also need to advise our clients that this will be broadcast in some component out to the public, and if people are savvy enough, they can watch it. So our clients need to know that that is happening. And I think that we would do them a disservice by not advising them. And my hope, and I know David and I talked about this, is that would also provide people an avenue or an incentive to privately resolve their disputes. We know that won't happen with everybody, but can you imagine being on the eve of a hearing and then dropping the bomb that this will be recorded on YouTube? We have to prepare our clients appropriately in that regard.
And I think also it's going to require some cooperation from lawyers, which sometimes seems like an impossible task. But it seems to me, if Ryan and I were going to try a case against each other, that she and I might come to an agreement as to those items that would not actually be spoken on the public record. Maybe we'd give the judge a list of those items in advance. Maybe we would give the judge a list of where those items can be found in the evidence. And instead of referring to Dr. So-and-so said X, Ryan and I might agree that we're going to say the statement made by Dr. So-and-so on page 6 of the report, paragraph 3, is what we're referring to here, Judge. That report won't ever be put up on the public screen. It'll be an exhibit that the judge will already have. And so if the parties are truly concerned about it, and if the lawyers want to do a good job on behalf of their clients in protecting their privacy, they have the opportunity to do that. It's a little more cumbersome, and Ryan and I would have to get along, which we do. But I think you can have the opportunity to do a hearing like that that's very well organized, very well ordered, and very well prepared.
And I think even more than saying Dr. X, I mean, we can go so far as if the preparation is there, you're going to say, Judge referring to Exhibit A.
Right.
And then we don't really even, you know, we just have to train ourselves. This is just a new world. And I just think it's, as I was indicating, I think there's also a lot of favorable opportunities with these Zoom hearings that a lot of people probably haven't realized, like particularly in family court. So often a litigant leaves something critical at home. Well, now they're at home, so they can go and get that document. Often from a court standpoint for custody and parenting time, I'm interested in what the physical premise of their house looks like without having to appoint a guardian ad litem. I can ask them to take me through their home on their Zoom camera. I can check out kids' bedrooms. I can see what's in the refrigerator. I can see if there's utilities working or not. So things that we used to have to delay, or I would have to, in the real world, I would have done a scheduling order, and I would have indicated I want photographs of the inside and outside of their home brought to court. Now I can literally look at that live. I had a hearing yesterday where they were disputing whether the bedroom was appropriate for the children or not, and the mother was being overly cautious, and the father was indicating that everything was fine. And so that was an opportunity for me to just resolve that issue very quickly. So there's benefits as well as drawbacks.
So one thing that I wanted to talk about is, and I've been getting private emails from attorneys for, the past couple of weeks on this topic, ever since we did the evidentiary hearing webinar. But one attorney contacted me yesterday, and then I'm going to ask Melissa Pierce to share her story because she has something that's going on. But he was going to be filing a motion to make one witness's testimony confidential because it had to do with, well, I don't want to get into the details, but it had to do with a child. So I don't know what happened with that motion or if it's even been filed, but I'm just wondering, like, sealing a record is a really difficult process. But how would judges feel about a motion that doesn't seal but just makes confidential one witness's testimony, or make something narrowly confidential to protect privacy? I don't know if if any other judges want to pipe in about that, but Judge McCarthy, I would like to hear what you think about it.
Well, I think like anything else, a proper motion to sequester or proper motion, and you would be asking the court to stop the live streaming for that particular litigant, I'm sorry, the witness or litigant, whatever. But again, that is going to be very narrowly interpreted. Our Supreme Court has made it abundantly clear that there is a right to an open courtroom, and that preempts almost everything else. Clearly, matters involving in juvenile court with children's testimony, you could ask to stop the live streaming. I think in our juvenile court, in our family court, it's bifurcated, but we're being very careful about making sure we're not live streaming things that would be inappropriate. And it's a matter of a few minutes of shutting off the live stream and then re-engaging the live stream. So I think that's appropriate. Clearly, in a lot of cases, it is going to be narrowly construed by the judges.
Mm-hmm. Melissa Pierce, could you share, if you're willing to share the situation that you're filing a motion? Are you filing a motion for the whole case or the whole hearing, or just for part of the case?
So we actually had the hearing on Monday. And there was a couple different motions, but one of the issues involved bullying of the minor children and how that impacted their mental health. And right from the get-go of that hearing, the referee had asked us, both attorneys, if we wanted to close the hearing and take it off of YouTube Live because of the issues that were being presented. Of course, both of us made our arguments why it should be closed, and he willingly agreed that because of these issues for the children and the likelihood that these bullies.
Both attorneys agreed? And in your case, both attorneys agreed?
Yeah, we both agreed because of the best interest of the children. But I mean, it's something you have to be willing to make, and maybe, you know, as was mentioned before the hearing, talk to opposing counsel and see if that can't be a stipulation put out.
Let me be clear though, just because the attorneys are stipulating to it, that doesn't mean you can close the courtroom. So again, I think it's going to be very narrowly construed because our Supreme Court has made it abundantly clear these hearings have to be open to the public. Even with stipulation, I agree on a bullying situation where the kids from the school might be watching and that becomes a source. But again, this is not going to be the standard that we're just going to start shutting off live streaming, or it shouldn't be.
So Judge McCarthy, here's a question, and if you don't know the answer, that's okay, because we're all trying to figure this out. But what is the standard? What's the?
There isn't one.
How do we figure it out?
There
what
isn't.
would I argue on appeal? I don't even know.
Yeah.
I mean, I see is what this order says, right?
I think it's common sense, but the attorneys have to appreciate that the court itself can't simply agree with them, even though they've stipulated to that.
Ms. Speaker,
Yes, Judge Hegarty.
a thought. If what you're doing is a sidebar, it's a sidebar. If what you're doing is receiving substantive evidence, then there's a concern.
No,
I agree. I mean, I don't think that we make tiers in our justice system of you're wealthier and you think your stuff is more private, so you get to close the YouTube versus somebody that isn't sophisticated enough to do that. I just don't think that that's appropriate, and I would encourage us as attorneys to not file in every single case a motion to turn off YouTube, just like we wouldn't file a motion to seal records in every single case. It's a misuse of what we're supposed to be doing. But a sidebar or going and having an in-chambers conference with a referee or the judge, I think should be off YouTube and is completely appropriate to guide the parties effectively.
And this is David. I don't think this is as so much, although we're talking about this in the context of Zoom hearings, I think the analysis is no different than a motion for a particular witness to, and I know one of the chat things popped up on my screen as well, motion in before COVID that said, Judge, we'd like to close the courtroom for this particular witness. I think it's the exact same analysis. We're just asking to close the courtroom virtually instead of actually preclude anyone else from being there live in the courtroom. And I do agree, Ryan, it's a limited circumstance where that applies. And I know the court rules, I wasn't prepared, Lisa, to answer this, but I know the new version of the court rules actually has a different standard about what courts can and cannot do vis-a-vis sealing the record, which is similar to closing the courtroom. I was trying to pull it up real quick while everyone was talking and couldn't.
If I could be heard, it's Judge Hegarty again. So your citations are MCL 600.1420. For good cause shown, the court may exclude from the courtroom other witnesses in the case when they're not testifying. That is the first place you look. That's a sequestration rule. It continues. And may, in actions involving scandal or immorality, exclude all minors from the courtroom unless the minor is a party or witness. That's the second part. Then you've got Michigan Court Rule 8.1116.1.
See anything, which is fine. I don't have to actually watch them, but
Except as otherwise provided by statute or court rule, a court may not limit access by the public to a court proceeding unless, and this is conjunctive, meaning all three must be met. A party has filed a written motion that identifies the specific interest to be protected, or the court sua sponte has identified a specific interest to be protected, and the court determines that the interest outweighs the right of access. B, the denial of access is narrowly tailored to accommodate the interest to be protected and there is no less restrictive means to adequately and effectively protect the interest. And C, the court states on the record the specific reasons for the decision to limit access to the proceeding. Now, there's an ability for any person, including a member of the public, to move to set aside or object to entry of such an order. There's an obligation that the court enter a true copy of the order to scale. But respectfully, I don't know that this rule is as high a bar as some may think, as long as you touch each of the bases. That's my thought.
And Wayne County Circuit Court has already made a determination that things like, obviously, parental waivers, matters where children involved in juvenile proceedings are testifying, or children are testifying, all will be excluded from YouTube. So again, a lot of this is common sense. It's the same as what you might do, as Mr. Mendelson was indicating, in the real world.
So there's a lot of things to touch on, and there's a lot of comments in the chat that I'm not gonna be able to get to all of them, but we should try to get to some of them. One of the things we talked about was in chambers conferences, and I think the idea that we explored in our meeting beforehand was to use a breakout room to have that in chambers conference. And have any of you had the opportunity to use that function?
Yes, I mean, I have. I don't know about the attorneys, but every morning the judges here are instructed to set up, breakout rooms, and I have a judge's conference room, a plaintiff's conference room, and a defendant's conference room. And I make my JA and my clerk co-hosts, and they are using those conference rooms as well to bring litigants in there to have conversations, make sure that their email addresses and physical addresses are updated. Those are things that we're doing normally now.
Yeah, I haven't done it in the context of a court hearing. I do it all the time in the context of my mediations, both with separate rooms and then rooms that I can pull the attorneys in when I just want to speak to them, or the experts in when I just want to speak with them. And it's relatively simple. It's, I think, very effective. And I think it allows for those same kinds of conversations that we would typically have at the bench on a sidebar conference or back in chambers with the court, which are critical. I don't know that we can function without having the opportunity to have those sidebars with the court.
Go ahead, Judge McCarthy.
I was just going to say, and as Ryan said, I think clearly the court's emphasis, not only for this incredible backlog that we're all facing, but I think that the knowledge that your private matter is going to be shown on YouTube, whether it be for 5 minutes or an hour, is an impetus for people to really try to mediate and resolve their cases. There's just very few reasons why a case should be going to trial.
Yep.
So Judge McCarthy, you mentioned one of the things that you do in chambers is get the updated information, like addresses and phone numbers. And Judge Thane posted on the chat a bit ago, for all of us right now that we see on the screen, we have our name and our picture. But for those people on latter pages, sometimes all you see is their phone number. So one of the things to remind our clients and the witnesses we're calling, if they're calling in on a phone, they need to, I don't know how to do it. If they're doing it on a phone, and I don't know if the administrator can help with it, but their phone number is displayed for the whole world to see, including the people who are on YouTube Live.
Right, there is a way to change that, and in fact, even the host of the conference can actually rename. So they would put like a P in front of my name if I'm a plaintiff's attorney. So I think the JAs in Wayne County are mostly doing that to keep that straight and re-identifying people. I had a hearing yesterday morning, a referee hearing, and my client came in as Tina, and his name is not Tina. So there was a big question of, is that his name, whoever's app he had been using to use the technology. And I'm like, there's a little bit, I don't know if it's Tina or not, but let him in, and then we were able to see it.
Or was it his girlfriend's name, which would be a real mistake.
Hey, it's a post-judgment, so don't worry.
We've already had a lot of fun with that, with people coming into the Zoom meetings, and I'm getting daily emails, some of which I can't even share publicly, especially if the Supreme Court's going to be looking at this, but people naming themselves on Zoom very inappropriately. So yes, with the phone numbers and everything, we immediately, before any hearing starts, the judicial assistant and the court clerk are changing for privacy reasons, letting one person in at a time. So everyone's waiting in the waiting room. That's obviously another privacy feature we have set. Everyone's in the waiting room. And so that is not being shown live on YouTube. They're bringing one in at a time and using the chat function at the bottom of the screen to ask them that question, indicating please review to the chat function, and letting them know right away when they bring them into the hearing room that they are streaming live on YouTube and to act accordingly.
A good
Another
tip
thing I
for
just
our
wanted to put-
clients is to tell them is to change their Zoom name from their Zoom dates to when they go to their Zoom court, okay? Because people date on Zoom now, so maybe they should change their name when they go to court.
Yes, that is so funny. That might be explaining why we're getting.
David?
I was gonna say, one of the things that I think we have to be careful of, and it's kind of ancillary to this naming issue, is people sometimes feel that because they're sitting in their house or they're sitting somewhere else that they're not in a courtroom. And my experience thus far is that you see litigants blurting out, which I know it does happen to all our judges on the call. I know it happens live, but it doesn't happen as frequently. And I think it's our job, and hopefully the court can help us with this, to remind people that we're in a courtroom. We're supposed to be dressed appropriately. Our clients are not supposed to be screaming out, "That's a lie, that's garbage, that's not true." And they don't have that same feeling of the command of the courtroom. And I think we have to get that back if these hearings are going to be successful.
Mm-hmm. One important point that was made on the chat, and I meant to mention this earlier, but PPO hearings and adoption proceedings are not to be live streamed. Those are not public proceedings. And just to clarify, if you have a PPO or adoption proceeding, those are all closed by statute. So I don't have the statutory provisions offhand, but just keep that in mind. Attorneys, Ryan and David, you had some ideas of maybe some agreements, not to close down a hearing, because like Judge McCarthy said, attorneys really can't agree to that. But you had some other ideas of agreements that the attorneys can make with each other that might help protect the privacy of the clients. And David, do you want to share some of those ideas that you were talking about the other day?
Sure. So I think, again, and I think this is a practice that honestly is maybe long overdue anyway. I think lawyers need to get together in advance. I think they need to get the majority of the exhibits stipulated to in advance. And certainly any aspect of any exhibit, whether it's stipulated to or not, that is confidential, needs to be placed in a binder, whether it's an electronic binder for the court or a hard copy binder, so that we're not putting exhibits up and we're pre-marking and pre-admitting as many exhibits as we can. So that, for instance, tax returns, normally in a courtroom, we might hand it to the witness, identify it, mark it, put it into evidence. That's all a waste of time anyway. But in this world, we're now going to have to, in theory, put that up on the screen. And so whoever's watching is going to be able to see the tax return with the Social Security numbers and whatever the case may be. If we do that in advance and it's already pre-marked and pre-admitted, all I have to do is refer the witness to Exhibit 1 in the book that's been delivered to them, because we've now delivered a book to the witness of all the admitted exhibits as well. I think that's also going to, Ryan and I talked about this, trying a case over Zoom is going to be challenging enough. Getting the right exhibit in front of the witness is going to be doubly challenging. And if you want to do it without putting it up on the screen, it's going to be even more challenging. And the way to do that is to get some agreements about exhibits for sure, and things that will not be said on the record.
And also, I think, getting those, just like you indicated, getting those pre-admitted, there's no reason, a motion before trial, and it might be something that us as trial judges need to keep in mind, that we set maybe a final motion date a week before trial so that we can agree on all the exhibits. David, you had mentioned that in a call offline that, these are also, look at it this way, these are also additional billing opportunities, with all due respect, for perhaps your support staff, that now they have to go through and make sure that all of your documents that you're submitting are redacted. You know, there's positives and negatives. You could have somebody charging to make sure that all of those things are properly redacted with names and dates of birth and phone numbers, things that you didn't concern yourself with before.
Yeah.
Right, yeah, absolutely. I used to write on the top of the pages that I would, when I'm preparing for a hearing, the children's names and dates of birth. And we have to remember that while that's something we've been conditioned to do, immediately we need to revisit our settings of how we're going to present certain aspects in these hearings in order to protect our client's privacy. And it's going to require us to prepare a little bit more as attorneys than maybe we would, and be cognizant of our new normal. But it's not something that will be so massive to overcome that we won't be able to do it. We just have to work on it.
And judges as well, reminding, as I've been doing, you know, we just started back this week, and you know, reminding people right at the beginning of a hearing, please be mindful that we're Zooming, we're live on YouTube, and please be mindful not to share any personal information, dates of birth, etc., about your children. You know, we as judges have to drive that, as well as the formality. And David, and you're so right about that. And that's, you know, I thank people when they're addressed appropriately now, appearing by Zoom. So it's to reinforce that behavior.
Ryan, did you have any thoughts to share about the exhibits when you're like cross-examining somebody and something comes up that you hadn't exchanged already, about like maybe the procedure for keeping it private?
Yeah, that's going to be probably the trickiest thing, is cross-examining somebody that maybe isn't is a non-party witness of how you want to present that information. And we had kind of talked about sending an email to that witness as they're on the stand. They should be able to open it on their device. Can you confirm that you received an email from me at this date and time? Yes, I can. Can you open that email? Yes, I can. Can you open that email attachment? Yes, I can. Can you identify what's on your screen? Yes, I can. What is it? It's my Chase credit card statement. Okay, you see the line that I've highlighted here. What is that? You know, Tapper's Jewelry, $14,000. And that's how I think is going to be a new way to do that, so that those witnesses don't know. It doesn't undercut our entire cross-examination surprise.
Yeah. Sending all the exhibits in advance, right? People get leery about showing their cross-examination outline. And Ryan's exactly right. We're going to have to be creative. You won't be perfect, right? There'll be some things that you're just going to throw up on a screen and share a screen. And if it's not the most secretive of confidential information, I think Judge McCarthy, you're right. I can put up that credit card statement if I black out the credit card number.
Right.
I can put up that credit card statement if I black out the type of things that we're worried about for identity theft, and still potentially point that witness to the line that I want them to look at. And so I might do a combination of both. I might have them in the email authenticate that it's their credit card, and then on the screen, so that I can now ask some questions that our judges can follow along with, have a redacted version of that and represent to the court that it's a redacted version. And I suspect if there's ever a complaint or issue about that, you'll put them side by side with the court at some point in the future. So I can see a combination of both working, where we do the authentication if need be, if we couldn't get that stipulation in advance, and then cross-examine on the material without showing the personal or private information.
Right, absolutely. Because the concern is, while the YouTube tapes are taken down immediately, the concern is that just like any of us, we can pull out our phone, somebody else can record it. There's apps to do so. I think that's been a lot of the conversations that we as attorneys have been having to try to safeguard. So I think the court's doing the right thing by taking down those YouTube after they come up. The concern is somebody that really has that nefarious purpose logging in, and we just need to be cognizant of that. While it's a small percentage of the population, the risk is still there.
And ironically, and I didn't mean to interrupt, Lisa, we're talking about neighbors and people involved in the case. But if you think about our day-to-day lives, if we think for a minute that the ambitious hackers and identity thieves aren't fully cognizant of the fact that all these court hearings around the country are now being made available on some video, and there's going to be all sorts of information, and they don't have to leave their house to get it, like social security numbers, we're mistaken. They are so resourceful as it is. It's amazing to me what those people are able to accomplish. And so I'm certain that there will be, when Ryan mentioned nefarious connected to our case and just nefarious.
Right.
One of the other things I suggested when we were all talking too is maybe it's going to be a routine submission that you're going to have a stipulated mutual injunctive order. And instead of the normal injunctive order that you can't squander assets, you're going to have an injunctive order that you're not going to tape the proceedings, or that there would be penalties if that in fact was the case. So that's another thing that could be done right up front with these cases.
I really like that idea. That's a really good idea. Would you sign an order to that extent, Judge McCarthy?
Oh, absolutely. I think in this world, it's imperative. And then the court has an actual repercussion if it's violated, versus now I don't know what repercussion we have.
Probably none.
David, did you mention the possibility of the attorneys having a stipulation about, not exposing confidential, or, something that would bind the parties to be make them more aware that they had to be very careful about not exposing confidential information? Absolutely.
And what I had thought about was literally identify, and in this really horrible time, right? I mean, we're talking about trying to figure out how to deal with our cases, but our whole world is in crisis. Judge McCarthy's right. There are some things that we can take from this that might be better. And one of the things is that lawyers are, if they want to do this right, are going to have to get together. And I'll use Ryan, since she and I have had a number of cases together and worked together on a number of cases. We could sit down and literally go through all the exhibits together. And even if we don't agree upon it, agree upon the type of information that should never be placed in the public record. We know the simple things like social security numbers. You start with dates of birth. You start with driver's license numbers, all the things that could be problematic, and literally create a list that we can submit into an order to Judge McCarthy, or just a written agreement with Ryan would be good enough for us, that this information, we're going to redact it out of our exhibits, maybe provide the judge with a complete set that has that information, but the exhibits that we submit will not have this agreed upon identification or information that we've identified as never being placed in the public record. I think that it's going to force all of us to actually be better prepared, which isn't a bad thing. And we'll make it just easier because we won't have to think about it. We will have done it in advance when we're trying our case.
And I've always long said that the more prepared you are in working up a case, the less likely that this case is ever going to go to trial anyway.
Right.
No truer word.
Right.
What about the children's name? I mean, should we just be using initials when you're in your hearing, or?
That's going to be tricky when everybody names their kid the same first letter, as seems to be the trend these days.
I do when possible anyway, Lisa, even before COVID, I would try to use just first. I certainly, in my written pleadings, I would only use initials. And on the record, I would, every now and again, you're not perfect, right? But on the record, I would try to only use initials as well. I just don't see any need for it.
Yeah, and I think the year of the birth is a good identifier, or just simply the age. I mean, at the end of the day, the judge, when they're thinking about their case or taking in testimony, I'm going to be, thinking about a child differently at 13 than I am at 6. So, though it's not necessary to identify by name, but their initials or the year of their birth is something you could do, or not even that, just the age.
Absolutely. And at least I saw a chat thing pop up, which I thought was a good comment, which is maybe the idea that we're not going to put certain types of information into the public record be incorporated into that restraining order idea that Judge McCarthy mentioned at the beginning, that we come up with a list of, at least a basic list that this type of information will not be placed in the public record. And that's something to consider. I hadn't really thought it through, but I saw the comment pop up and it sounded like an interesting way to deal with the lawyers that can't necessarily get along so well.
In addition to the YouTube recordings, I mean, that should be in your confidentiality agreement, that the litigants will not be sharing anything that's posted on YouTube with any third party.
Yeah.
I was going to call on Matt Kachik, who knows something about what Ohio's doing. I'd like to hear what it is.
Well, before Judge Young left the bench, Joan Young, who I think is one of the smartest women to ever, sit on the bench in any family law court in the state of Michigan, she really was promoting what the state of Ohio has a model of confidentiality that now post-COVID, I think is even more important for us to really look at. And I understand and appreciate and respect open courts and the requirement, but I mean, given YouTube and the ease with which someone can record something off of YouTube and confidentiality, and like David was saying earlier, back in the old days, we knew exactly who was watching a court appearance and when. I would love for this to be an opportunity to really embrace confidentiality more than ever, and I wish that's where it was headed.
Matt, can I respond to that? I actually worked with Judge Young. I drafted up a statute that I presented. She and I worked on together, and we tried to get it up through the legislature, and it just never got all the way through dealing with this very issue. I'm wondering if it's not a bad idea for me to dig that out of my archives and.
Not a bad idea. This might be
perfect timing. Yeah.
Yeah. So when you mentioned Judge Young and this issue, it dawned on me that I actually have worked on this with her and tried to get that through, and it just died. But I don't know that the appetite was the same then that it might be now. So I might reach out to you and send it to you and get your thoughts on it as well.
So what is the gist of it?
The gist of it was certainly a lot of the things that you're doing automatically now relative to the children, relative to issues regarding abuse, issues that are personal to the parties needed to be private from the public, that there was no reason, unlike other cases, right? Most commercial cases just are what they are. These are families and children, and we needed to have a different confidentiality standard relative to them.
Agreed.
David, would you be willing to share that with the family law listserv?
I would, but I have to find it first. So it might take me a little while, but I have it somewhere, I'm sure, because it was a lot of time and effort on it. So.
Yeah. So one of the things, and a lot of the questions I've been getting have been about referee hearings, because referee hearings are being treated the same as judge hearings as far as being put on YouTube. And here's the thing, historically, nobody ever, I mean, in my view, nobody ever goes to referee hearings. You might be in court watching for your own interest, or just because you happen to be there for something else, you're in the courtroom watching other cases for a while. But if you have with the referee hearings, it's like a lot of them are very small rooms. There would never be, the public would never be in the room, to my understanding. And now all of those referee hearings are being publicly broadcasted, which is a very different situation than what I think the referees and the people who go to the referee hearings are used to. Panelists, do you have anything to share about that?
Well, I'm going to say, referees are held to the same standard as a judge. And the benefit is, even when our proceedings started to be taped on video, I think it makes you a better judge. It makes you a better referee. It makes you a little kinder, gentler if you know that the whole of anybody is out there watching you. So I think that there's benefits there. And certainly judges are elected officials and we're accountable to the public. And we should always be acting professionally, and referees, although they're not elected, I mean, that's the position that they're taking. They're held to the same canons of ethics. And so I think it's just gonna bring out the best in everybody.
David, I wanted to see if you could address, or Ryan as well, normally back when we used to go to court, I used to read transcripts of, the parties would be getting divorced, they'd come to a settlement and they would put the settlement on the record, and then you get the details of the settlement on the record. But that's going to reveal a lot of information that we may not want our neighbors or bosses or whatever to know about. Do you have, advice for the attorneys about how to handle those divorce settlements so we can get that judgment of divorce entered?
Yeah, I mean, I think that we can certainly prepare a settlement agreement that's comprehensive and refer to it. We do that in a number of cases. I know when we spoke, and so the settlement agreement's incorporated into the judgment, but not part of the public record. And we would typically provide a copy of that settlement agreement to the judge to make sure it has all the bells and whistles. Having said that, I think sometimes people abuse that process, and certain things I think need to be in a judgment. And that's something that I think we'd have to be cognizant of. But I think that's the easiest way to do it, is to have a settlement agreement that's incorporated but not referenced. If you don't do that, I still think that you can hand a copy of the judgment to the court that has all the bells and whistles. And I understand that that's part of the public record, but someone has to go get the hard copy. You can voir dire your witness, and you can simply ask them to look at paragraph 4 of the judgment. They understand that's your spousal support provision. You understand what you're receiving. Yes. You understand that what you're paying. Yes. You understand that it's non-modifiable and that's what you've agreed to. Yes. You understand, all those things without actually putting the critical information on the record. I think you can do both with or without a confidential settlement agreement.
And what I'm hoping to do to enter a judgment that has a confidential settlement agreement, I haven't tried this yet, but I'm set to enter a judgment later this month with a confidential settlement agreement, is email and provide that to the court staff separate, as a separate PDF from the rest of the documents that are to be entered. And I think that the court staff and all kinds of sophisticated enough to know that doesn't go in the court file. You can put a heading on it, cover page on it, and email that in so the court has that to refer to, just like how we would physically hand that to the court staff and then get it back.
Yeah, in our computer system, just like a confidential exhibit, those could be submitted, your judgment of divorce be basic, and those could be submitted in confidential manner, and then they would be attached in Odyssey in a confidential way that the public could not have access to, or any attorneys, but the judge could, so that if issues came up about that agreement later on down the road, it's preserved.
Right. Right. So I think that's a really easy way to do it, one way or the other. Again, I think the overriding notion is, if you figure out what you don't want on the public record, find a way to give your judge the information that he or she needs to do what they need to do to confirm your judgment and point them in the right direction.
David, I thought you had a really good idea. I never thought about this, but you could start numbering your paragraphs. And so then you're referring to paragraph number 7. You could say what the heading is, and then you could have everyone agree, that this is as written, that this is what you're agreeing to, without going into specifics, if that kind of detail was put in a judgment.
Yeah. And Lisa, to your point, even if you're relying on 2507 because you're putting the settlement agreement on for the first time, you can do it that exact same way. If both parties, kind of combining all of this together, you confirm that they're looking at the exact same document that you're looking at, that the judge is looking at. You confirm their agreement with that document. You go through the numbered paragraphs without putting the important information on the record. I am as confident as I can be, right? There's always some ambiguity that will hold up to a 2507 challenge if someone said that was not an agreement placed on the record in open court. I do not see our Court of Appeals or anyone else looking at that and not thinking that satisfied the requirements of placing something on the record.
So we have a lot of really great ideas here for protecting privacy, and it's all the examples that we're talking about come from when we have 2 great attorneys on the case who are willing to work with each other, and everything takes, as we've, I think, recognized, it's going to take more time, more planning, and so on. But what do we do when either we have an attorney who's not willing to cooperate, but even worse, if we have an improper on the other side? So I don't know if you folks have dealt with that situation.
Judge McCarthy mentioned, I haven't dealt with it, but she mentioned if you put some of these in orders about things that won't be placed on the record, there's now some teeth if people want to misbehave. That's, to me, the only answer to that. You can't force people to be decent, but you can compel them to comply with the judge's order.
And I think, like a lot of things, right? Once somebody violates it and a judge holds somebody accountable, word gets out, that this happened in Oakland County, or this happened in Wayne County, so beware. But to your point, absolutely. Are we going to have the same level of preparedness with the pro se? No. By and large, maybe unfortunately, you're usually not dealing with any substantial assets in those cases. So you don't have the, let's say, necessity for confidentiality, but most of our free legal aid clinics are preparing those documents, and perhaps just having them I'm going to go to them now and suggest to them that each of their paragraphs and their standard judgments be numbered instead of just titled. And so we can just start pushing that out across the state. And I think like anything else, as people start doing it, some of these practices will just become commonplace.
So when do we do those orders? Do we, is that something that comes out of the pretrial conference, or, I mean, I feel like it should be done earlier than later.
The confidentiality agreement?
The orders about what's gonna, like as far as what's not gonna be allowed to come out during the hearings, the things that are gonna help keep the attorneys in check or an improper in check.
I think it should be as soon as possible. I don't know that there's a process yet. We're all just learning as we go. I think that the lawyers that cooperate will do it as soon as possible. The ones that don't might end up having to file a motion to get that entered. Or if the courts individually or by county decide that they want to issue a blanket order, I don't know that you get much objection. And I know probably everyone on this podcast would be willing to weigh in and assist.
Yeah, I would start signing ex-parte orders that involve confidentiality, not sharing anything that was live on YouTube, some basics. Absolutely.
And I'm going to start adding it to my ex parte orders, just like we've had, you can't destroy electronic evidence or emails or restrict online access. Just add that as an additional line item. For a case that's already pending, you could add it to a DSO, a scheduling order, or some other status conference order. Livingston County has a pretty standard DSO they issue at the outset of their cases, and that would be easy for them to add something like that right at the outset.
I also think SCAO might be able to come up with like a sample order. It's not going to necessarily be for all cases, but then maybe there's a checklist, and then the parties can, or the judge can check off the things that are going to be confidential and not revealed during the case. And that would just to save time, not to have to recreate the will every single case, because almost every case is going to have some level of confidentiality needed, even if it's just, driver's license and social security and phone numbers. But there's obviously the medical, the financial, the children, depending on the case, are going to have all these different aspects that need to have protection and privacy.
Yeah, STAO order would be great.
Hey, Lisa, I know we're running short on time, but one of the things that I thought about after we all spoke earlier this week that was really a concern was how to deal with other people being in the room when a witness is testifying. And I was thinking about something that actually happened in a mediation that I didn't mention on our call. And I wanted to hear what Judge McCarthy and if any of the other judges wanted to weigh in. I wonder if we can insist that a witness who is testifying wear headphones. And the effect of that would be, while the person in the room could hear their answer, they wouldn't be able to hear the question. And it would make it much more difficult for a witness to be coached if they can't hear the question before they have to answer, as a way to potentially prevent that person being in the room when a contested hearing is taking place and being coached or coerced. I mean, it's not coached, it could be coached or coerced. It could be either one, certainly on PPOs or whatever the case may be. And I was wondering if that was something the court might want to start or consider. I don't know. I haven't thought it all the way through, but I thought about it as a way to prevent that issue.
Yeah, just real quickly, because I know we're running out of time. It's a great idea. It's a great idea. I don't know that we can insist on it, but could that be a standard of practice? Yes. And as I indicated, the other thing is to use your phone or your camera and you zoom around the room so that you show me who else is in that room. And I think that should be a standard practice to ensure that no one else is in the room, as well as, making sure that no virtual backgrounds are being used that can mask other people's in the room's identity.
Right.
That is an excellent idea.
And I know it was a little off topic, but it was something that was really sticking with me after our meeting earlier this week.
That's a great idea.
Yeah, does our panel have any final comments before we wrap this up?
I gave mine.
Yeah. It's not required.
And, it's a new world, and we all, there's going to be pros and cons to all of it. And I think it all offers a lot of opportunity, like not having to drive down to court, not pay for parking, all of the things, not sitting, most of us are setting up specific times for your appearance. That's a huge opportunity and so much less of a time suck for instead of, 20 lawyers sitting in the courtroom. You know exactly when your hearing is, you make sure you're there on time and you're going to get your, your 15 minutes of justice. And I think that's a much better model way than we've been doing it. So I think there's a lot of positives to this.
Yeah,
Thank
I agree with Judge McCarthy. I think there are a lot of positives, but a couple points I want to remind everybody. There's a filter to make your face prettier on Zoom if that's a concern. Train your clients and practice the technology with them in advance, and don't show up in your pajamas.
And Ryan, there's only so much you can do with this face, so I'm not going to even try the filter.
But you wore a suit, so.
I did wear a suit today.
Thank you, all three of you, for helping out today. I really appreciate it. And for everybody who attended, next week we're doing a webinar on virtual parenting time. So I'm really excited to explore that because it's becoming more prevalent, unfortunately.
Lisa, thank you for putting this together. These are terrific, and I appreciate the invite to do this. This was helpful to me as well, so thank you.
You're welcome. I'm going to stop the recording here.